Good day, everyone. Welcome to another YES talk here at the North Suburban YMCA. We're welcoming today Matt Margolis. He is talking about estate planning 101. Um, this talk will last about an hour. We ask participants to please save their questions until the end. Sorry, I lost my screen. Sorry. Okay, Matt will talk us about today, will teach us about the importance of estate planning, no matter what our level of wealth. Discussion will cover what is important to include in your estate planning and how to use trust and other tools to protect your loved ones. I've heard this talk a couple of times, and every single time I hear more things that I need to be concerned about right now that I should be doing. So with that, I would like to welcome Matt Margolis to the talk today from Margolis Weldon Law.
Thanks.
Welcome.
Thanks, Pam. All right. Well, good morning. Thank you, Pam. My name is Matt Margolis, and my partner Lauren Weldon and I together have a what I'd call a boutique elder law and estate planning practice in downtown Park Ridge. We help people with from 18-year-olds. We draft power of attorney documents for 18-year-olds going off to college, all the way up to doing full-blown estate plans for folks in their 90s and triple digits. So we really kind of span the gamut as to the age of the individuals that we serve. We work with single individuals, married couples, from all walks of life. Everybody's welcome to come to our firm, and we help everybody and anyone that would like to engage in some planning. And the other half of our practice is on the elder law side. So we don't just do wills and trusts. We have a strong focus on helping people protect assets and apply for Medicaid. My partner Lauren is the one that really focuses her practice more on that side. And so we do a lot with kind of working with seniors and their families that are, kind of going through a transition of moving into a nursing home or assisted living facility, and helping determine what benefits they might qualify for. If it's Medicaid, we can help apply for that, et cetera, and just kind of help guide families through that transition. And when it comes to that, to be very honest, there's so little that we can do. But there's a lot that we can help kind of support families with, and help connect them to all the right people and other professionals that are out there that can assist with other things. Because, when we're kind of going through a transition like that, the legal piece is just one part of the puzzle, right? There's so many other people that really can help with that transition. So, we understand that we're just one part there. So that's, a little bit about us. So today, estate planning 101, trusts aren't just for the Pritzkers. Funny thing is, I think one of the first times I gave this talk after I titled it, gave it this title. I think I was at the North Shore Senior Center, and one of the relatives of the Pritzkers was actually in the crowd. And I felt a little bashful for giving it the title that I did. I just told her she should feel great for being in that family. All right, so on to the talk. I will keep the chat box open. Just a little bit of housekeeping on my end. I think Pam already mentioned this. For everybody to keep themselves muted. I know that she'll kind of police that a little bit on her end. And that's not that I don't want people to talk. It's just sometimes there's background noise that kind of takes away from the conversation, and it impacts other people's abilities to hear what I'm saying. Not that I'm the most important person in the world. Believe me, I'm not. But I will keep the chat box open, and I will be looking at it. So if you have questions as I'm talking, and if you're like me, you'll forget about them, please feel free. If you understand how to use that chat box, please feel free to type questions in that chat box. Whether you want to type them to everyone, or if you know how to type them, if you want to type them just to me, or you want to type them just to Pam. Any of those are options, and I will be looking at it. And that's great, because it allows me to then kind of finish my thought, and I can take a look at the chat box, and I'm happy to answer questions as appropriate as I'm talking. If it's a question that's very individual, I might wait till the end. In general, I like questions to be a little bit more broad for purposes of the conversation today, versus questions that are very, very individual to any of you. those would probably be more appropriate to answer offline between the two of us, and not necessarily, with everybody else in the room, so to speak. So, okay. So, when we look at estate planning, at the end of the day, it really comes down to two main documents. And listen, there's a lot of options when it comes to estate planning. Estate planning can get very, very complex for people. Don't get me wrong, right? So, I mean, I'm going to let you know things that we're not going to cover today are, people that might have ultra wealth, where, we start looking at like things called charitable remainder trusts. And there's a whole other slew of different kinds of trusts that we use for people that have, tons and tons of wealth. We're not going to discuss any of that today. Okay. That's not the average person. And those are not the people that we serve in our law firm. So, when those people come to us, we typically refer them to colleagues of ours. So we're not going to cover, topics around estate planning today that are related to the ultra wealthy. We're also not going to cover anything special needs related today. I just want to be very clear on those two points. Okay. Really, the point of today is to really cover what we discuss, 98% of the time, right? And that's wills and trusts. Right. These are the documents that are going to be pretty important and relevant for the vast majority of people. All right. And so when we do planning and we sit down with somebody, and when somebody's considering doing some planning, typically there's sort of like a fork in the road. And the idea is, do we go down this path of putting a trust together, or do we go down this path of putting a will together? And most people, when I sit down with them, they have no idea what the difference is. And that's not a bad thing, right? I had no idea what the difference was until I started practicing in this area of the law 13 years ago. Okay. So I certainly don't expect the average person who doesn't do what I do on a daily basis to know the difference. A lot of people come in and they have this idea, unless they've talked to somebody, unless they've maybe had their financial advisor or their CPA or their mom or their dad or their best friend say, you should have a trust. Most people come in and say, I need a will. And it's just because the idea of a will is so ingrained in our heads. It's in movies, TV shows, right? People always, if they refer to any kind of document, we've always heard the will. Right? In movies, you see, and I'll tell you, this is not how it works in real life, right? You see like the reading of the will, right? In the attorney's office with all the old books on the bookshelf, and there's a fire going, and the family's sitting around, and the will's being read, and everybody's hearing about, what Grandma Jane wanted to do with all of her stuff. And just so everybody knows, that's absolutely not what happens in real life. Okay. Definitely not in our law firm and any of my colleagues' law firms. But again, this idea of the will is just something that we're more familiar with. But I can tell you right now that the vast majority of people these days will put together a trust. Okay, and the type of trust that they'll put together is a revocable living trust. But let's step back for a second, right? Let's talk about a will. So, and I'm going to pick on myself because it's the easiest person to pick on. Even though I could just, pick one of your names and we can start to have fun that way. So we'll pick on me, right? So, like many of you, right? And I can do some presuming here. I think it's safe. I've got some stuff, right? And we've all got our own version of our stuff. You might own a condo, you might own a house, you probably have a checking account, a savings account, maybe you have a brokerage account, you might have an IRA or a 401k, maybe some life insurance. You've got some combination of that stuff, right? And so let's say I've got some of that stuff. And so I've got a house, I've got some bank accounts, I've got an IRA, a 401k, and a life insurance policy. And life is good, right? I'm going along with my life. Everything's great until one day it's not, right? And it's because I don't wake up the next day. I pass away. And I hate to tell you guys that we're all going to die. Hopefully that's not the first time everybody's hearing that. We are, right? And that's why we plan. And so one day I pass away, and the question becomes, where does all my stuff go? Now, I'm married. And so I can say that for a lot of married couples, and I'm not saying every married couple, All right. Notice I'm not saying every married couple, but for a lot of married couples, we have this built-in estate plan. Right. And I'm going to pretend like I've never done any estate planning before. And I promise you I have. Um, a lot of married couples have this built-in estate plan without even knowing it, at least when the first spouse dies. Definitely not when the second one does. My built-in estate plan, if I've done nothing at all when I die, if I'm married, is that in a lot of cases, and this was the case before my wife and I did any planning, okay, because we didn't do planning immediately right when we got married. I'll be very upfront, even though I was an estate planning attorney at the time. We owned our condo jointly in both of our names. All of our bank accounts were owned jointly. My wife was the beneficiary of my IRA. I was the beneficiary of her 401k. We didn't have life insurance at the time because we didn't have kids. And that was about all we had. If I died at that time, even having done no planning at all, everything would have gone to my wife based on joint ownership of assets and beneficiary designations. Now, I'm going to throw a wrench in this. Even if I had a will at the time that said everything goes to Pam Rakansky, the best employee at the YMCA, the reality is Pam would get nothing. I know, boo-hoo. Pam would get nothing at all, and my wife would still get everything because beneficiary designations and joint ownership supersede language in a will. Okay. So I just want that to be very clear to everybody. So again, a lot of married couples can sort of escape having issues when the first spouse dies, sort of just by luck, because they tend to own things jointly, and whatever they're not joint on, they're beneficiaries for one another. Now, again, that's not every married couple, but that's a lot of them. I've met with a lot of couples over the last 13 years. All right. The issue tends to happen when that second spouse dies, or when that, never married, that single individual dies. Why? Because that person has everything in their name only, right? Their checking accounts are in their name only. Their savings accounts are in their name only. Their condo is owned by them only. Their house is owned by them only. They might have beneficiaries named on their 401k or IRA or life insurance policies, probably, right? Maybe it's their siblings, maybe it's their nieces and nephews, maybe it's their parents, maybe it's their good friend, maybe it's their boyfriend or girlfriend or partner or whatever they're calling them. If you're my 85-year-old aunt, your friend, so some of those things might have answers, might have solutions because you've got beneficiaries named on them, but a lot of them don't. And so those are the assets that we see issues with. And so let's say I know that I'll die before my wife. I know I will, but let's just say that my wife dies before me because it's easier for me to talk about myself again. So my wife passes away before me, and now all the assets are in my name only. I've got beneficiaries in the 401k, the IRA, and the life insurance. So at my death, those go to my kids. Now, hopefully, I've updated the beneficiaries to name my kids, or hopefully during my lifetime, I had my wife as the primary beneficiary with my kids as the contingent beneficiaries. Pay attention to what I'm saying, because I'll tell you right now that I've had clients where their spouse died, and then they died 5 years later, and they had kids, and they never named their kids as beneficiaries on their IRAs or 401ks or life insurance policies. They never had their kids as contingent beneficiaries from day one, and they never updated those beneficiary designations when their spouse died. That to me is awful. It's awful on the part of the financial advisor that's managing those assets, or the insurance agent that sold them that insurance product. And it's pretty irresponsible on the part of, I'm not just going to blame the person that sold them those products. It's pretty irresponsible on the person who owns that life insurance policy. Those things should not happen. Okay. So please, if you take away nothing else from today, go look at your beneficiary designations. Okay. Make sure you don't just have your spouse. Make sure you have successor, make sure you have contingent, not successor, contingent beneficiaries. Okay, please. Don't just wait and be like, well, if this person dies, then I'll name a backup. No, name that backup now. All right. Good deal. So here's what happens when I die and I have assets in my name only that don't have a beneficiary on them and that are not owned jointly with somebody else. Okay, with or without a will. I'm going to say that again. With or without a will. If I have assets that are in my name only at the time I die, they go through probate. Now, there's a little caveat, assuming those assets are over $100,000, because there's a way that we can avoid probate. If it's a couple checking accounts or savings accounts and the total is under $100,000, we can avoid probate. Okay. But if you own real estate, I don't care what the value is, it's going through probate. And I don't know too many people that own any real estate that's worth less than $100,000. And it's not the equity that you have. So even if you own a condo that's worth $250,000, but you only have $70,000 of equity, it doesn't matter. It's $250,000. Okay. So let's say I've got some assets now in my name only when I die. It might just be the house. The house could be the only asset. And for a lot of people, it is. Because some people, they're like, I've got everything covered. I've got beneficiaries and everything. But they forget about the house or the condo. Right? I've always got those clients that come in and they're like, I'm so smart. I just like added my kids as joint owners on every single account of mine. So I don't need a will. I don't need to do any planning. If I die, the accounts are in their name. I don't like that either. Yes, we get to avoid probate. We'll talk about what probate means in a second. I'm okay with you adding your kids as beneficiaries on your account. I am not okay with you adding your kids as joint owners on your account. If it's a checking account with like $5,000 or $10,000, fine. I still don't like that, to be honest with you. There's better ways to solve for that. I'm not going to go into all those details today. But we can solve for the idea of your kids having access to it if you need them to. Putting your kids as joint owners on investment accounts and brokerage accounts and checking accounts and savings accounts, and worse yet, those clients of mine that add their kids onto their house. Guess what? Your kid gets sued. Your kid goes through a divorce. They are as much of an owner of those assets as you are. It doesn't matter that you just did that as a matter of convenience. The law doesn't look at it like that. So somebody sues you for something, now your liability could impact your mom or dad and their house that they just put you on the title of. Okay? Or if I'm talking to the older adult, then your child's issues could impact you. All right. Somebody asked a question. There is a way, and I normally don't always talk about this, but there is a way to avoid probate using something called a transfer on death instrument with a house. So a transfer on death instrument, to be very brief, is a legal document. You file it, you record it with the county that you live in, the county recording office. Similar with a little more complexity to a deed, and it's basically like adding a beneficiary onto a house. Depending on the scenario and depending on who the beneficiaries are, in some situations we are all for a transfer on death instrument, and in some cases we don't think it's the best idea. So it really just depends on a case-by-case basis as to whether, at least we think it's a good idea to use one. But yes, using a transfer on death instrument is definitely a way to avoid probate with a house. Correct. It's a good comment. All right, I see another question in the chat box that somebody asked that Pam forwarded. I'm going to answer that a little bit later as we start to get more into talking about a trust. So let's talk about what probate means. Okay, because I talked about this idea that if I have assets in my name when I die, with or without a will, they can go through probate. Probate is a court process, and I'm not going to beat a dead horse and go talk about this for a long time. Probate's a court process where, again, if I have assets in my name only, right, no beneficiaries, not owned jointly with somebody, at the time I die, regardless as to whether I have a will or not. And I know I'm saying that like 5 times, but I can't tell you, majority of clients that I meet with, majority think that a will avoids probate. It absolutely does not. Look at a will as like a letter to the judge, basically saying, hey, dear judge, I know that you're in the midst of this probate process of my estate, but I want you to read my will. Here's my will, and here's what I want you to do, right? I want all my stuff to go to my wife if she survives me. And if she doesn't survive me, I want everything to go to my 2 kids in equal shares. So look, just remember that. Remember that the concept of that will being like a letter to the judge. And in your will, really what you're doing is you're naming an executor who's going to manage your estate, make sure that all your stuff goes to the people you want it to go to. But before that, all your bills get paid, your house gets sold, all the administrative things happen first. 99% of the time, your executor is going to hire a lawyer to navigate him or her through the probate process, because most executors are not just going to go through probate on their own, right? There's a lot of forms. It's a court process. It's like sort of like handling a divorce by yourself. Most people hire a lawyer for a divorce, just like most people hire a lawyer for probate. The average probate estate, I would say, sort of in Cook County or Lake County, where we do most of our work, for a simple probate case, right? Meaning there's a house, maybe 5 to 10 bank accounts, investment accounts, and I don't care if it's a $500,000 estate or a $3 million estate. I'd say most simple probates, sort of as I just described, probably take about 12 to 18 months from start to finish. Maybe I should probably even say maybe 18 to 24 months at this point, if I'm thinking like the last 2 years, and probably cost somewhere between $5,000 and $10,000 of attorney's fees and court costs. Court costs are pretty minimal. It's mainly attorney's fees, because in probate you're paying attorneys hourly. And again, our goal is to be efficient, but the time just adds up, unfortunately. Okay. I'd say the goal in most cases for most people, and again, I'm saying this based on doing this for the last 13 years, I can tell you that over 90% of the people, probably 95% of the people that we've worked with over the last 13 years have had a desire to avoid probate. Right? Most people would say, I don't want my estate to go through the court system, to go through probate. And here's the thing, right? If my estate goes through probate, I'm not the one dealing with it. I'm dead. Who's dealing with it? My wife, my kids. If you don't have kids, maybe it's your nieces and nephews, your brothers and sisters, whoever you're leaving your stuff to, right? They're the ones dealing with that process, not you. So at some point, attorneys much smarter than me, which I know is very hard to believe, came up with this idea of a revocable living trust. Okay. And the revocable living trust, which we're going to talk about today, and I'm just going to refer to it as a trust from now on, but I want you to know that it's a revocable living trust. This is the most common type of trust out there. Chances are, if you have a friend or family member or somebody that has mentioned that they have a trust in place, chances are it's a revocable living trust. Okay. These are popular because we can make changes to them over time, right? As long as I have capacity, right? As long as I know what's going on, I can make changes. The trust operates off my social security number. I file my taxes the same way as I always do. Trust doesn't change my life in any meaningful way. Really, what it does is it offers me the protection of avoiding probate. That's really what it's going to do for most people. Now, for a small percentage of people, we're going to use the trust not just to avoid probate, but also to avoid paying some estate taxes. Now, I'm not going to really go down that path, other than telling you that Illinois has a $4 million estate tax exemption. Okay, what does that mean? That means that at my death, I can pass on up to $4 million to my beneficiaries, tax-free. When I say tax-free, because people are always wondering, like, what does that mean? Are there any taxes when somebody dies? Meaning the taxes, when somebody passes away, the taxes are taken out before they go to the beneficiaries, just so you know. It's not like the beneficiaries get the money and then all of a sudden it's like, oh, I just inherited $500,000 from my mom. I've got to pay $100,000 of taxes on that. It's not how it works. Okay. So if my estate is under $4 million and it gets distributed to my kids, there's no taxes, no tax consequences. I mean, if they inherit IRAs, as they take distributions from the IRAs over the course of their lifetime, they're going to pay taxes on that. But most of you know that that's how IRAs work, right? You take a distribution from an IRA and you pay taxes, capital gain. I mean, not capital gains, income tax, right? It's just like getting paid. But there's no taxes, okay? No estate taxes. Now, if I have more than $4 million when I die, right? Great problem to have. I'm sure we'd all agree. Most people don't have that problem. I promise you. Again, I've been doing this long enough, met with enough people. I know the percentage, at least that runs through our office. If I have more than $4 million at the time of my death, then there will be taxes. Let's say I have $5 million. There will be tax on $1 million, not the whole 5 million, but the million that's over the 4. So there'll be tax on that $1 million that gets paid, and then the remainder goes to my beneficiaries. Okay, so it's not like the beneficiaries get it and then they pay taxes. Just to be clear. But in general, really all I'll say about estate taxes is more so for a married couple. If they have an estate tax problem, right? If a married couple has more than $4 million, we can use trusts to help avoid paying estate taxes. It's a little bit trickier with a single individual. Our opportunities to avoid paying estate taxes when we're over $4 million as a single person is a little bit more difficult. For a married couple over $4 million, it's easier. And that's because each person has a 4 million, each person in the couple has a $4 million coupon, so to speak. Whereas that single person has more than $4 million. It's kind of hard. It's a little bit harder to plan around. Okay. So again, that's really all I want to say about that. If you're a married couple, you got more than $4 million, good for you. Great problem to have. You should 100% be looking into doing some planning, and you should be making sure that you're putting trusts in place, and 2 trusts. Okay, not just one. It should not be a joint trust. All right. So moving on. So the revocable trust. So for a lot of married couples or single individuals, kind of works for obviously in either way. But again, it's easier to pick on myself. My wife and I, if we have an estate that's under $4 million, we use a joint trust. Okay. And so the only thing I'll say to what I was saying before is if a married couple has more than $4 million, they use 2 trusts. Okay. And then there's some details as to why you use 2 trusts. So if a married couple has less than $4 million, for the most part, we're going to use a joint trust. Again, if they have more than 4 million, we'll use 2 trusts. There's also some married couples that might get married later in life and they keep their assets separate. If that's the case, then we'll probably use separate trusts. Maybe it's not so much for estate tax purposes, but we're just going to keep their assets separate, right? We're not just going to start combining their assets in a joint trust just because we can. So my wife and I create a trust together, right? We've got the Margolis trust, and we are what's called the trust makers, right? Pretty original name, I know. We're the ones creating the trust. It's our assets that are going to go in the trust, and I'll talk about what that means in a second. We can make changes to the trust over time, right? So we decide 10 years from now, we want to leave money to a charity, or maybe we want to set money aside for a niece or a nephew. Great, we can make changes. But maybe in 40 years, we don't have capacity. We can no longer make any changes to the trust. Whatever the trust says, that's it. We are also the trustees of the trust. The trustees are who can control and have access to what's in the trust. Let's talk about what that means. For a trust to avoid probate, right? Because one of the things I said in the beginning was that in most cases, we're using a trust to avoid probate. For a trust to avoid probate, we actually have to retitle our assets into the trust. This is so important, guys. I can't tell you how many times I've had clients come to me that have put trusts together with other attorneys in the past, and they fill out our personal information form, sort of like our intake form, and it has them write down, what type of accounts they have, and and how they own those accounts, right? Is the account just in spouse 1's name, spouse 2's name? Is it owned jointly, or is it in a trust? And I can't tell you how many times I've got clients that come in with trusts that they put together in the past, and that column I would expect to see that some of these accounts are owned by the trust. They're not. And the accounts are still owned by them jointly. Or maybe they're just owned by spouse one or spouse two. So when we put a trust together, fantastic. All right. For most people, they feel really good about getting their estate planning done. I've yet to meet a client where after they signed their documents, they were like, ugh, I hate this. I never wanted to do this. Right. Typically, that's not what people say. Most people are really excited to get it done. Right. Because a lot of my clients are in their 50s or 60s. I'd say the average client that we work with is probably between the age of 50 and 65. Average, maybe 50 to 70. I know it's a big range. And so most of them have been saying, we wanted to do this 10 years ago, 15 years ago. We talked about doing this when our kids were minors. Thank God nothing happened to us because we would have needed a guardian and we never appointed one. So people feel good about getting these documents in place. So number one, after we sign these documents, people feel good. Great. But we're not done. Okay. Most of our work as the attorney is done. Right. So what we will always do for our clients, and I can't speak for other estate planning attorneys, we will always help retitle real estate. Right. So if our clients own a house or a condo in Illinois, we will put together a deed and record the deed with Cook County, Lake County, McHenry County, wherever they live, and we'll transfer title of their house or condo to the trust. That's how you avoid probate with the house or the condo. It's not just creating the trust, it's making sure that the asset is in the trust. Now, as it relates to the checking accounts, the savings accounts, the brokerage accounts at Wells Fargo or UBS or JP Morgan, those assets have to be retitled to the trust as well. We don't physically do that for our clients, but we sit down with our clients. We go through every single account they have. We tell them exactly what they need to do with every single account. I tell them that if they have issues with the bank or the financial institution, they can call me or they can have the bank call me. We want to make sure all of that gets done. Once all of the assets are retitled to the trust, here's the thing. Assets are either retitled to the trust or there's beneficiaries on them. Certain assets will not be retitled to the trust. IRAs and 401ks and any kind of retirement account, 403b, right? Any kind of retirement account. That does not go into the trust. It cannot be retitled to a trust. But that gets controlled with a beneficiary designation. Again, back to what I said in the beginning, make sure those beneficiaries are up to date. And you've got not just a primary, but a contingent. Same with those life insurance policies. In some cases, we might name the trust as the beneficiary of the life insurance policy. In some cases, we might name our spouse as the primary beneficiary of an IRA or 401k. We might name the trust as the contingent. Kind of depends on our situation. Most cases, we might name the trust as the contingent if we've got minor children. And I'll kind of explain why we might do that. Okay. So again, it's great to put the trust in place, but there are still some steps that we have to take to make sure that we're avoiding probate. Most of these clients that come in, I tell them, I'm like, I'm glad you're still alive. For a number of reasons, obviously. But one is you put this trust in place to avoid probate, and if God forbid something happened to you before you came to my office, you wouldn't have avoided probate. Your estate would have still gone through probate, even though you paid more money for the trust than the will. And that's just the reality, right? And that's not just with us, that's with anybody else. The trust is going to cost a little bit more to put together than a will. I'm not going to give you guys my fees today. So don't bother asking me in the chat box, just to be blunt. But make sure we're doing the things that we have to do so that these documents work for us, right? So when I talked about the idea of my wife and I being the trustees and the trustees having control of the assets, now that all these assets are in the trust, the checking accounts, the savings accounts, the brokerage accounts, the house, as trustees, we still manage and control that stuff just like we did before we had a trust in place. And again, remember I said before, the trust operates off our social security number. Nothing changes in our lives, guys. Nothing. We file our taxes the same way. I tell my clients all the time, the biggest difference you're going to notice is your statement from the bank rather than saying Matt Margolis, Christina Margolis, and then our address, it's going to say the Margolis Trust, Matt Margolis trustee, Christina Margolis trustee, and then our address. That's it. Everything else, same as before. Now, we're the trustees to start with, but we need to name successor trustees because at some point, we know that for sure we're both going to die. But before that, we might both be incapacitated. Or I might be dead and my wife might be alive but incapacitated. So who's going to be the trustee to manage the assets in our trust in either one of those scenarios, right? Where neither one of us can be a trustee due to incapacity or death, right? So you can name as many people as you want. You can name them sort of like naming executors of a will. You can name people together as co-trustees, just like you can name co-executors of a will. Or you can name one at a time. I always say the more the merrier, as long as they're people that we trust. No pun intended. Some people struggle to name one or two people. Some people can name 5 or 6 people. Everybody's different. If we only have one person to name, we might consider naming a corporate trustee, maybe like a bank or a trust company, as the caboose, as the last in line. Just God forbid the individual that we named doesn't survive us or is incapacitated as well when we need them to act. At least we've got a corporate trustee, a bank or a trust company to step in and act. Okay, so there's different options. All right, I'm going to go up and answer a couple questions. One of the questions was, somebody has a trust and has an investment asset that needs protection after death. Is the way to handle this by making the trust the beneficiary? I'm not really sure exactly what that question's asking, to be honest with you, especially talking about needing protection after death. I would say for that person to send me an email and try to clarify that. And if it's something simple enough, I can answer that maybe in a quick email. If it's not, we might need to schedule a meeting to discuss things a little further. That's a little more. That's just I'm a little bit gray on exactly what you're looking for, and I don't want to take away from the meeting today to try to figure that out. But I'm happy to figure it out offline. Who decides if someone has capacity to make changes in the trust? A doctor. So at least the way that we do it in our office, that's my answer. I'll tell you that a lot of times if an adult child is reaching out to us on behalf of their parents, I will always ask. I don't care if they bring up dementia or memory loss or anything like that. I will always ask, does your mom or dad have capacity to sign documents? Because in my head, I'm thinking, why are you reaching out for mom or dad versus mom or dad reaching out for themselves? Now, for sure, if I hear any buzzwords or if we hear any buzzwords, mom was diagnosed with dementia, mom's had some issues with memory lately, we are 100% going to ask for a doctor's letter. Not to be mean, but we want to make sure this is for a couple protections. We want to make sure that if that client's signing documents, whether they're signing documents for the first time or whether they're maybe updating documents, especially if they're going to be updating documents and maybe disinheriting a child, I want them to have a doctor's letter that says they have capacity to sign legal documents. That protects them, because if they sign those documents, they die, and then somebody wants to fight after they die and argue that they, why was I not left in the will? Why was I taken out? Blah, blah, blah. If there's a doctor letter that said that person had capacity to create the documents, that's really hard to fight. But without that doctor's letter, it might be a lot easier to say, oh, we see that in the records, there was a diagnosis of dementia. People can have a diagnosis of dementia and still have the capability to sign legal documents, right? It just depends on where they're at in that dementia journey, all right? So I've had plenty of clients with a diagnosis of dementia sign documents. We want to make sure we get that doctor to sign off, okay? So just to answer that question, the doctor makes that determination. I know some attorneys that will make that determination. I think that's wrong. Unless that attorney is a doctor as well, I just don't think I think you're kind of playing with fire. Another question, should beneficiaries of retirement accounts be the trust? Again, in some situations, and I'll talk about that right now, actually. So that's a great question. So we talked about trustees. Now we talk about beneficiaries, right? So the trust is for the benefit of my wife and I during our lifetime. Might sound silly, but that just means that just like if we didn't have a trust, if we had those checking accounts in our name or the brokerage accounts in our name jointly, well, they're for our benefit. Well, the trust is for our benefit, right? It's the Margolis trust for me and my wife. But at our death, at least for our trust, after all administrative expenses are paid, houses sold, etc., everything goes to our kids. We have 2 kids. It goes to them in equal shares. When we leave money to beneficiaries, we can leave it to them in one of 2 ways. We can leave them money outright, meaning let's just say there's $1 million after all taxes, expenses, whatever are paid. There's $1 million. The trustee, let's say it's my brother, he writes each of our kids a check for $500,000. They can do whatever they want. That's an outright distribution. Now, what's pretty common when we're talking about leaving money to younger beneficiaries is that we would leave them the money in trust. Now, this isn't a separate trust. This isn't like we're drafting a separate trust to go along with the trust that we're setting up. Okay? It'd be like 2 trusts that sort of spring out of our trust. One for the benefit of our son, one for the benefit of our daughter. $500,000 goes into each one. My brother is the trustee, and he manages the money for them. And the way that our trust operates is that the money would sit in those trusts until our kids turn 30, each of them respectively. And that was just the age that my wife and I picked. When we were talking about it, we kind of thought about, our friends and the 2 of us, and we kind of thought, by 30, you kind of are who you are. And I have this conversation with a lot of my clients that have younger kids like us, because a lot of them are like, what age should we pick? 21? I'm like, no way. Your kids would be in college. You want a college age kid inheriting the amount of money that they might inherit, especially if you're. And for most younger couples, they don't have tons of money at that point, but a lot of them have big life insurance policies. So if something were to happen, unfortunately, at a younger age, there could be significant money. And there's some younger couples that are fortunate to already have a ton of money. Do you want a 21-year-old, going to the bar in college with $1 million in their pocket? I don't think so. So we leave them the money in trust, right? And my brother's the trustee, and he manages it for the benefit of our kids. And he can use it for their health, their education, and their general support. And then when they want money for other things, hey, Uncle Mike, I want a new car, or I want to go take a trip with my friends, or I need money for a wedding, or I want to put a down payment on a condo. Well, guess what? Uncle Mike, the trustee, I always tell my clients, look at that trustee as like a surrogate parent from a financial standpoint only, right? Because if you were still alive, they'd go to you for money. Now they go to Uncle Mike, the trustee, and he gets to say yes or no, just like you would have gotten to say yes or no. So you're picking a trustee that has hopefully similar values to you, and that you feel like would treat your kids the same way that you would have treated your kids to some extent, right? In a perfect world, my kids are over the age of 30 when we pass away, and the money does go to them outright. So that whole age 30 goes to them in trust. That's really just a protection if something, God forbid, happens to both my wife and I before they turn 30, okay? So the comment about should the beneficiary of retirement accounts be the trust, when we're talking about situations where we've got younger beneficiaries, in most cases, what we will recommend is that, while my wife is the primary beneficiary of my retirement account, the trust is the contingent. And the trust is the contingent because if something were to happen to my wife before me, I would want my retirement account to go to the trust, because by going to the trust, those retirement assets would not be accessible by my kids until they're 30. Whereas if I named my kids outright on the IRA as contingent beneficiaries, if something happened to me at an earlier age, they would have the money as early as age 18. Okay, so I hope that clarifies things. So again, it's not like a one size fits all to that question, Kimberly. It's really dependent on the age of the beneficiaries, their maturity, what's going on, who we're leaving money to, And these are just, conversations again that we have with our clients. It's not like we just look at it in a bucket and we're just like, all right, this is what we do with everybody. It's really, what does your specific situation look like and what makes the most sense for you? I want to make sure I cover everything. I think I've gone into a lot of detail on some things I think maybe I don't always do. And so because we've got about 15 minutes left, I want to make sure that I kind of run through some things that I want to take care of. So, every time we leave money to beneficiaries, we have to think about the fact that they might not survive us, right? And this is uncomfortable to think about because, when my wife and I were sitting down to do our planning, I had to have a conversation with my wife and say, what if our kids didn't survive us? And by the way, when we did our planning, our son was 3 months old. Right? Talk about a terrible question for somebody who's postpartum. Right? So what if what if your kids don't survive you? What if your beneficiary doesn't survive you? Where does their share go? We have to think about these things. We want to plan for these things. We want to I want to ask my clients these difficult questions, not to make them sad, not to make them cry, but I want to plan for the worst case scenario and hope for the best, obviously, so that they don't have to come back to me in 10, 15, 20, 30 years if something happens that we could have accounted for. Again, not that we wanted it to happen, but we could have accounted for. Just like the idea of naming contingent beneficiaries on an IRA, or even third in line beneficiaries on an IRA. You don't do that because you want these people to pass away. You do that just because it's good planning. All right. My goal is to plan as much as we can for clients, to take as much as we can into account so they don't have to come back to me and pay me more money every time something happens that we could have accounted for. All right. All right. For the sake of time, I'm going to start to speed up just a little bit, even though you probably noticed I'm a fast talker anyway. Every time we create a trust, we always create wills. All right. When we create a trust, the will that we create with it, we refer to it as a pour over will, sort of like a pour over coffee. It still says last will and testament on it. Some attorneys actually write pour over will, but it's still called the last will and testament. We just refer to it as a pour over will. And here's why. Remember, I talked about this earlier. We can still go through probate with a trust, right? Because if I don't put all my assets in the trust and there's some asset in my name only when I die, it goes through probate, even though I have a trust in place. So the pour over will does a couple things. I name executors, right? Who's going to manage the estate. And then the beneficiary of my will is the trust. So the beneficiary of my will is the Margolis trust. Simple. My will doesn't go into all this detail about my kids and them turning 30 and how they get it. And if one of them passes away, who gets it, blah, blah, blah. Doesn't talk about any of that. My will names executors. It says that my trust is the beneficiary. And then for those of us that have minor children, the will is where we name guardians. Whether it's a pour over will or whether we're just putting a will together with no trust. Okay. The will is where we name guardians, right? So who would take care of my kids or my wife and I's kids in the event that neither one of us survived our youngest turning 18, right? And like naming executors or trustees, we can name as many guardians as we want. We can name a married couple. We can name single individuals in order. In addition to wills and trusts, anytime we're doing any kind of estate planning, there's other documents that are really important that we put together. Powers of attorney. In Illinois, we have two types of powers of attorney: healthcare and property. All right. The healthcare power of attorney, we're naming somebody to make medical decisions for us in the event that we cannot make them on our own. Right. So if I'm incapacitated, who's going to make medical decisions for me? This is the healthcare power of attorney. I can name as many people as I want. It is one at a time in a specific order. Now, I always tell people you've got to be selfish when you're naming powers of attorney. I have a lot of clients that are always concerned that they're going to hurt one of their kids' feelings because, even though their youngest daughter is the best person to name as the healthcare power of attorney, they think that they're going to offend their oldest son because he's the oldest, right? And he should be the power of attorney. Listen, I'm a really nice guy. I promise. I know that sounds cheesy to say. I'm a big teddy bear. But I tell clients, I'm like, I don't care. If your daughter's the right one, you name your daughter. This isn't about hurting, I appreciate that you're concerned about hurting your son's feelings. I totally appreciate that. But you have to do what's best for you. And you know what? Being a power of attorney is not a gift. So many clients think like, oh, my son is going to really want to be my power of attorney, or he really wants to be the trustee or the executor. Yeah, until you pass away or you're incapacitated, and he comes to me and he's complaining about how much work it is. Being a power of attorney or a trustee or an executor is not fun. It's not. It's a job. It is. My parents, when I sat down to do their planning, of course they want to name me in every single role, right? This is what I do. So I expected that. But if I could hand it off to my brother, I would. I would. It's a lot. So, talk to the people that you're naming as trustees, as powers of attorney. Make sure they're okay stepping into these roles. Make sure they're comfortable for the healthcare power of attorney. Make sure they're comfortable making a medical decision for you. Make sure they're comfortable making the medical decision that you'd want them to make for you, right? I don't want my life artificially prolonged, right? If things don't look good, I'm not saying don't try a little bit, but don't just string me along to string me along. Don't just keep me hooked up to machines forever. That's absolutely not what I want. And you know what? I can tell you 99% of people that I meet with don't want that either. So make sure that the person you're naming is okay doing that, because you might find out that they're not. You might find out that they're not okay, quote unquote, pulling the plug, for lack of a better phrase. So have the conversation with the people that you're naming, truly. So we got the healthcare power of attorney. Again, we can name as many people as we want. It's one at a time in a specific order. Then we've got the property power of attorney. The property power of attorney is who can make decisions for me with respect to everything that's not medical and everything that's not in the trust. Because any assets that are in the trust, my house, bank accounts, investment accounts, that will be the trustee. So if I'm incapacitated, any assets that are in the trustee will manage, the successor trustee will manage. But there's plenty of assets and there's plenty of things that will come up that my property power of attorney will deal with that will not be in the trust. Again, remember, IRAs, 401ks, those are not in the trust. Those stay in my name. Who files my tax return if I'm incapacitated? My power of attorney for property. Who deals with issues for some of us later in life if we're not yet 65 with Medicare? My property power of attorney. Or Social Security? My property power of attorney. Who signs a contract on my behalf? My property power of attorney. There's a lot of things that my property power of attorney will handle. Again, we can name as many people as we want. It's one at a time in a specific order. In most cases, the people that we name as trustees of our trust, executors of our will, and powers of attorney for property, they tend to match up. It tends to be a very similar order. And what I tell clients is, I don't care. It doesn't need to be your son, the financial advisor, or your daughter, the CPA. I'm like, for some reason, people are like, that's what it has to be, because we're talking about somebody handling the things that are more financial. And then I look at my client, I'm like, but you're neither of those, and somehow you've been able to manage your whole life. Why do you feel like your power of attorney needs to be one of those? It doesn't. Your power of attorney for property or your trustee or your executor just needs to be somebody that's resourceful, somebody that's good at managing a household, somebody that's good at paying bills on time. Something breaks, they're hiring somebody to fix it if they don't know how to fix it themselves. That's a good power of attorney for property, trustee, executor. Okay? Because you know what? Your son, who's the financial advisor or attorney, or your daughter that's a CPA, they might be working 60 to 70 hours a week and trying to manage a family. So stepping in to manage your life on top of that might be really difficult. Last two documents, living will and the HIPAA. All right, HIPAA is the healthcare authorization, right? We're naming people that can have access to our medical records. Most of you have probably signed a HIPAA at some point at the doctor's office, hospital, letting people pass your records back and forth. We have clients sign HIPAAs so that they can give access to people that they love of their records. Here's how the HIPAA works. I've got my wife, my parents, my siblings, my in-laws on my HIPAA. There's no specific order. All right, I've got like 8 or 9 people on there. No specific order. Now, also, the HIPAA doesn't give them the ability to make decisions. That's my healthcare power of attorney. What can these people do? They can go to my doctor and ask for copies of my medical records if they want to. I don't really think most people that we name on our HIPAAs will do that, but they can, and we have to be comfortable with that. I like the HIPAA because if I'm in the hospital and something's going on with me, anybody on the HIPAA can call the hospital, go to the hospital, talk to the nurses, talk to the staff, and find out what's going on. It gives them that ability, and I like that. Last but not least is the living will. The living will is the do not keep me alive unnecessarily document. It's not the same as a DNR, which is now called a POLST, practitioner's order for life-sustaining treatment. We're not going to go down that path. We don't have enough time. But the living will is not as controlling as a DNR or a POLST. The living will is really a document that, so yeah, to answer the question in the chat box, it is not the same as a healthcare power of attorney at all, because it does not name somebody to make decisions for me. The living will is really just more direction to my healthcare power of attorney, telling them that I do not want my life artificially prolonged, that I value the quality of my life more so than the quantity. So a living will won't be appropriate for everybody. I have got some clients and they want their lives prolonged to the greatest extent possible. It might be just because they want it that way. But I've had some clients for religious purposes where for religious reasons, they cannot sign a living will, and their lives have to be prolonged to the greatest extent possible. So they would not sign a living will. Okay. So while most people will sign one just because they sort of agree with the concept of quality of life over quantity of life, it's not something that everybody will sign, of course. And yeah, definitely not the same as a healthcare power of attorney. I would definitely say, while I like the idea of a living will, if it would be one or the other, somebody should for sure have a healthcare power of attorney over a living will. But a living will for somebody that does not want their life prolonged unnecessarily, it's good to have. It's just more support for that power of attorney that they're naming to let them know, hey, don't prolong my life for no reason. All right, so I know I kind of went to the end here, not leaving a ton of time for questions, but depending on how much time
You have.
Yeah, I'm happy to answer any questions.
Are there any questions? I know we've been trying to get them through the chat box. Any questions from anyone else? If you do have any questions, feel free to email Matt or even myself at the Y, and I can get that question to Matt. Did anyone have anything? Right. All right, with that, I'm going to close this out. Thank you, Matt, for talking to us today from Margolis Weldon. Yep. And I put his information in there too. Feel free to contact me if you need any more of his information. Thank you. His next talk will be on November 1st at 9:15 again about elder law. It's a Q&A. So basically, he's just going to open it up and let you ask him questions for an hour. That one won't be recorded just because it's personal, more individual questions. So I definitely encourage you to check that one out. It won't be recorded, so you'll definitely want to be in attendance for that one on the Zoom. Next event is October 10th, next Tuesday at 11 a.m. 7 things you can do now to prepare for Medicare's annual enrollment. And then with that, I learned even more today, and I didn't think that I would have. Yeah, so thanks, Matt. If you want to check us out, check this video. If you missed any part of this, you can check us out on the podcast library at our YES on the NSYMCA website. Just go search for YES and you'll see our podcast library and you'll find that there. Sometimes I miss things and I have to go back to re-listen to it, so you'll find that there. Again, thank you, Matt, for talking to us today on this fine Wednesday. Have a great fall, everyone, and we'll see you hopefully next month.
Thanks, Pam. Bye, guys.